Good afternoon. Please be seated. World No Record in Prime Core Technologies, case number 231161. Good afternoon.
Good afternoon, Your Honor. May it please the Court, I can stand on behalf of McDermott, Lowe, and Emery on behalf of the debtors. Your Honor, today we're working off our amended agenda, which was filed, the sealed version at docket number 306 and the unsealed at docket number 307.
I have a copy.
Turning to the agenda, I'd like to thank Your Honor for entering orders on items 1 through 5, prior to the hearing. Item 6 on the agenda is the debtors' 2004 motion, specifically their omnibus motion for entry of an order directing certain individuals to sit for a 2004 exam, produce documents, and provide sworn interrogatories in response to our request. And I'd like to thank Your Honor for entering that order short in time so that this could be heard at today's hearing. As the Court is aware, the debtors have been conducting very thorough investigations into a number of case dispositive issues. And as part of that process, we have been reaching out to third parties to obtain this information. And although several parties have agreed to voluntarily comply with our request, there are some who have not, and there are some who have conditioned their compliance on entry of an order, the 2004 order. So in that vein, we filed our first omnibus 2004 motion seeking such an order, and this pertains to 3 parties that we're seeking to have comply with our 2004 request, and these requests relate, more specifically relate to the 98F wallet issues. I'm not going to mention the names of these parties before we've taken great strides to redact the names pursuant to the matrix order that Your Honor entered, and so I'm going to refer to them as party 1, 2, and 3. And we've met with each of these parties prior to filing the motion, as set forth therein. With respect to these parties, party number 1 has agreed to comply, but has conditioned such compliance on entry of this order. Party 2 has agreed to comply with the debtor's request. It doesn't have an objection to entry of the order, but I'm not sure if counsel is present on the virtual courtroom, because counsel took issue with a provision in the order that I'm not quite sure I understand what the reasoning is, so I would ask counsel to speak to that. And then the third party, party number 3, since the filing of the motion, has agreed to comply with our requests. So at this point, everyone is willing to comply voluntarily, subject to entry of this order. So I guess now I'll ask party number 2's counsel to, if he's present.
Let me ask, does anyone wish to be heard with respect to the motion of proposed form of order? Ms. Scrivener, good afternoon.
Good afternoon, Your Honor. I represent Party 1, and I just wanted to note for the record, my client has no issue sitting for the deposition, but because of various confidentiality agreements in employment agreements that he had with the debtor, we felt that it was necessary to have a court order in place beforehand.
Okay, thank you. Does anyone else wish to be heard with respect to the motion or the proposed form of order? Mr. Detweiler.
Good afternoon, Your Honor. May it please the Court, Donald Detweiler, Lowell Pond, and Silverberg from Brown Rudnick is on by Zoom. The committee wholeheartedly supports the relief requested and respectfully request the Court grant the relief.
I have reviewed the order. I don't have any issue with the form of order, and certainly I appreciate it's uncontested. But I did have a question about paragraph order, the 4th paragraph of the order. And I understand that it's relatively routine to allow additional discovery. I think this should be modified to say, in line 2, including without limitation, reasonable request based upon the information, and then also indicate at the end, without prejudice to the deponent's rights.
We're happy to make those changes, Your Honor. And would you like that under certification?
Yes, please. Yeah, and it's, I mean, I don't know how you want to word it, but I just want to make sure that the deponent's rights are reserved and the requests are reasonable, because it's kind of broad as written. But I understand you don't know what you're going to get in terms of discovery, so you need to maintain optionality, but I need to put a little bit of curb on it.
Okay, thank you, Your Honor. So with those changes, we ask that Your Honor grant the motion.
Absolutely, I'll grant it with those changes when filed under certification.
Great, thank you. Your Honor, before I provide a brief update on the sale process, there's one housekeeping matter I wanted to address, which is the protective order
Yes.
that we filed under certification of counsel.
I have a question about that.
Okay.
So first of all, it was brought to my attention last year that the United States Trustee's Office likes the opportunity to review protective orders before they're submitted under certification of counsel. So I'm glad to see Mr. Cudia here, because I want to know if the U.S. Trustee's Office had an opportunity to review it. And then also, I had a question with respect to paragraph, well, it's E. It's 3.2E on page 7. But if I could hear from Mr. Cudia, and I didn't mean to cut you out, unless you wanted to give a presentation.
No.
Okay.
Good afternoon, Your Honor.
Good afternoon.
For the United States Trustee. Yes, I have had an opportunity to review the protective order, and the U.S. Trustee is aware of it. We did ask for certain language to be entered as far as allowing us access, but the U.S. Trustee has not taken a position as to the relief requested.
Okay. Is the debtor and committee willing to allow the U.S. Trustee access?
Yes, those changes are already in the order.
Okay. Oh, okay.
Yeah, we made them prior to filing.
Okay, terrific. Thank you. My only question, and U.S. Trustee might want to stay around for this point as well. In paragraph E on page 7, this talks about documents being generated and being able to file them under seal without the necessity of filing a separate motion. And it references Local Rule 9037-1, and that really deals with PII. And I was wondering, was it intended here, this section, to deal with Local Rule 9018, which is the seal motion process? I wasn't sure what the interplay was here.
So, you're right, Your Honor. So, in 9037-1, we want to give, so under the matrix order, only the debtors are permitted and the claims agent are permitted to redact information. We wanted to give the opportunity to these third-party 2004 targets to redact their personally identifiable information or that of others without having to formally file a seal motion, and that's why it's triggered by that particular section. Also, that local rule, I'm not entirely clear, it requires a motion to redact. It references one. So we just wanted to have that sort of.
So I guess the presumption in E is that the only type of information that would be potentially redacted is PII, right?
Right. And I think here you're right.
Yeah, I mean, is that accurate?
No, I think we're going to have information beyond that because it may go into the C phrases.
Right.
So I think you're right.
So I think you should modify this to address 9018. And I don't know what the U.S. Trustee's position is on that. So I think the parties should probably consult and come up with a revised STIP. I just want to make sure that we were all on the same page as what was being redacted and when a motion's required.
Now, like I said, if it's going to be for 9018, I would like the opportunity for my client to review that.
Right. It's been your client's position. They want to review that. So do you guys want to confer offline and submit a revised STIP under cert?
Yes, Your Honor. I will note that we cannot get certain discovery until the order is entered. So I just ask that the Office of the U.S. Trustee take that into account.
Okay. And let me just make sure while we're here, because does committee have any position with respect to that?
No issue, Your Honor.
Okay. All right. I just want to make sure we avoid any issues down the road. So if you could confer and then just submit a formal order, that would be great.
Thank you, Your Honor.
Anything else for today?
Just the brief sale update.
Yeah, I would appreciate a status update. That would be great.
Our auction now is taking place tomorrow.
Oh, okay.
It was adjourned a couple of times. So it's taking place tomorrow. We're continuing continuing to negotiate with the bidders. The process is taking a bit longer than we anticipated, but expect to have a further, more fulsome update within the next week or so to present to the court.
So your next hearing in this case, I believe, is November 14th?
Yes.
Is that, if you need additional time, you'll reach out before
Yeah,
the...
actually, so I think that we're going to need a hearing before then, because I think we're going to file another 2004 shortly. And with the 14 days under the local rules, I think that if we file it today, that would put us the 8th of November, which isn't that far off from the 14th, but we are trying to get as much information into our hands so that we can put a more fulsome update in our supplement to the disclosure statement.
I don't have time availability. Let me ask you this. Do you need a 2004?
The next one we believe is going to be contested. While this one was uncontested, the next one we believe, given the parties involved and their positions they've taken thus far informally.
I'm just thinking out loud if there's a way to do a process that you can avoid multiple 2004 requests, but
We're trying to put people together in omnibus requests, but
which leads to another issue. It may be more helpful if the names are all one exhibit and you redact the exhibit as opposed to the names in the pleading themselves, and then you can just redact the exhibit. Unfortunately, I have no availability the 8th or the 9th, so perhaps the 7th?
yes, that works.
Could you do the 7th at 2?
Yes, Ron.
Okay. So with the auction being tomorrow, the 19th, and I just ask, and maybe this is a premature question, but otherwise, is the debtor's time frame still in place with respect to confirmation?
The nature of the bids is such that we believe they're going to be consummated through the plan as opposed to a 360 sale. So that's why we've adjourned the sale hearing and are focusing on confirmation.
Okay. All right. Okay, thank you. Appreciate the update. Is there anything further?
No, Your Honor.
Okay, then I'll just ask Mr. Logano to mark the calendar for hearing on the 7th at 2.
Thank you.
Okay, everyone, thank you. Have a great afternoon. We stand adjourned.